Second time's a charm. Let's not hit the power button this time. Jello again. This is Ben Hitchcock Cross talking to you today. I've got a reversal of decision. Um, like the first one for like 4 months, so that's kind of nice. This market, um, and the main thing I think we didn't have a video of this one. But the judge here is shocked, who is, I guess, colloquially known in the comment section as Judge Word Salad. Um, and I never thought about any issues of um, cognitive decline or anything else along those lines. But, a lot of other people have raised that. I would say, maybe that's reflected in this decision. We'll see. I It's just not something that I had really ever given a lot of coherent thought to. But I will say that the decision in and itself did seem to be the decision by the ALJ that this is reversing seemed to be incoherent. And at the time, I couldn't just tell if he was, angry, biased, and prejudiced or something else. Um, but this was sort of, you know, I guess there's kind of what the broader question is what's in terms of arbitrary and capricious standards, what is the difference between a decision by somebody who's in cognitive decline and a decision by somebody who's biased? Ultimately a good deal of expense for everybody. The decision of the administrative law judge is reversed. There was a trend to name the administrative law judge um, in these decisions, and then apparently they stopped doing that. That's outrageous to me. Outrageous. It should be named. This is the only place you'd ever see anything like that where they don't actually name the person without any good reason. The respondent shall cease and desist from discriminating against the complainant on the basis of use or non-use of lawful products off the respondent's premises during non-working hours. Now, we'll read about what they think the case is about. There's two sides of what this case is about. There's alcoholism as a disability. We're going to leave that to the side here. In Wisconsin, we have a law that prohibits discrimination on the use or non-use of lawful products. We've talked about that here as the Philip Morris rule, and where that came in my opinion, is when Philip Morris encouraged the legislature, possibly through financial means, to enact this law because they were worried about health care um, costs being applied to them. So they, the time of the settlement, the so-called tobacco settlement, part of the question is, what else is next? So the law here is use or non-use, which is supposed to be tobacco, but in Wisconsin, of course, the question is alcohol. Good. So a Wisconsin employer can prevent an employee from both drinking on the job, which that used to be sort of a question. Now it's almost not, and or showing up to work drunk. But they cannot prevent an employee from drinking on the job. And the interesting thing about this one is it also applies to they can't tell them what they can't use or not use. So that's meaning, let's say you want to use Callaway putters as opposed to I don't know what the boy, I got myself in dangerous territory there. But you want to use uh, your brand of trumpet isn't their brand of trumpet. You see what I'm saying? Selmer. I mean, come on, really? You're fired. You see what I'm saying? So you can't do that actually in Wisconsin. You can't fire somebody because they're black, and you can't fire someone because they prefer Selmer trumpets over much better ones, for example. What if they were a Yamaha man? Oh my goodness gracious. Okay, order. The respondent shall cease and desist from discriminating against the complainant on the basis of the use or non-use of lawful products of the respondent's premises during non-working hours. That the respondent, if it has not already done so, shall offer the complainant instatement to a position substantially equivalent to the position he held prior to his discharge. This offer shall be tendered by the respondent or an authorized agent and shall allow the complainant a reasonable time to respond. Upon the complainant's acceptance of such position, the respondent shall afford him all seniority and benefits, if any, to which he would be entitled, but for which the respondent's unlawful discrimination, including such leave and vacation credits. Well, that's nice. The respondent shall make the complainant whole for all losses and pay the complainant suffered by reason of its unlawful conduct by paying the complainant the amount he would have earned as an employee, including pension, health insurance, and other benefits, from the date the respondent discharged the complainant until such time as the complainant resumes employment with the respondent, or would have resumed such employment, but for his refusal of a valid offer of a substantially equivalent position. Now, let's just talk about the realities of that one. We call that reinstatement. Now, most people after 2 or 3 years have moved on, whatever that means. Okay. Or they just hate these guys because they've been making them do so much work for so long and denying what was patently clear to everybody. So they don't want to go back. The problem is that you can't not go back, because then you're giving up something valuable, because very likely the employer won't want you to go back. So in effect, one party doesn't want someone to go back. They have the right to go back. The other party may not want to go back. And everybody's sort of playing chicken on that one to see what's happened. I've told you before that I've seen people who insist on going in there and cuss everybody out, or insist on going in and resigning. Um, and I've seen almost everything in between. And I've seen employers pay a lot of money for people not to go back for even 1 second. Everybody's different. That's why this is an opportunity. What this is creating here is what I'm trying to explain to you, is an opportunity to negotiate. The back pay period shall be computed on a calendar quarterly basis with an offset during each calendar quarter for any interim earnings from the work of the complainant would not have performed had he remained employed with the respondent. Any employment insurance or welfare benefits received by the complainant during the above period shall not reduce the amount of back pay or otherwise allowable, but shall be withheld by the respondent and paid to the unemployment insurance compensation reserve fund or the applicable welfare agency. That's kind of interesting. Additionally, the amount payable to the complainant after all statutory set-offs have been deducted shall be increased by interest at the rate of 12% simple for each calendar quarter. Interest in the net amount of back pay due, that is the amount of back pay due after the set-off, shall be computed from the last day of each set calendar quarter to the date of payment. Pending any and all appeals of this order, the total back pay will be the total of all such amounts. I don't know, again, why they put that in there. There's going to be an issue that we're going to discuss here. And everything's political, I guess, so we'll talk about it. But what they've done here, well, I guess we'll just read one more paragraph. That the respondent shall pay to the complainant reasonable attorney's fees in the amount of $42,237.65. A check in that amount shall be made payable jointly to the complainant and his attorney, Ben Hitchcock Cross, and delivered to Mr. Hitchcock Cross. I would have preferred bullion, flowers. Might also, I wonder what $42,000 in flowers would have been, because I guess it's not a negotiable currency. Okay, enough of that. Here is, I guess we're getting to the meat and bones of this page anyways, that within 60 days of the date of this order is issued, the respondent shall comply with all terms of this order and file with the commission a compliance report detailing the specific actions it has taken to comply with this order. 2, now this is fascinating. The concurring commissioner would delay enforcement of the commission's decision until after all appeals have been exhausted, which would in fact be entering a stay without any evaluation of whether the respondent is entitled to a stay. That decision should be made by the court pursuant to Wisconsin Statute 22754, who, after providing the party with an opportunity to be heard, would decide whether a stay is warranted. In State versus Gundenschwager, which is, of course, what the guy's name is, this Wisconsin, the Wisconsin Supreme Court held that a stay pending appeal is appropriate when the moving party, one, makes a strong showing that is likely to succeed on the merits of the appeal, two, shows that it will suffer irreparable injury unless the stay is granted, and three, shows that the other party will not be substantially harmed, and four, shows that there will not be substantial harm to the public. Now, this footnote here is a footnote by the victor, that is the majority, writing about what the concurrent says. So this is a sort of a backhanded way of saying, you might be smarter than us, but we have more votes, and we're explaining why you're wrong. So the concurrence, that's the chairperson, Gillick, will have her chance to explain why she thinks a stay is warranted here. I don't get this at all, because it seems only to benefit the employer, and it seems to be completely without any legal basis, as they're saying. But again, Gillick is, from what I get, is like a liberal circuit court judge from Madison, from Dane County. So I don't get that at all. I really don't. I mean, I don't know why it wouldn't be obvious. So what they've done here, and I now know, is historically they do, apparently they had a 30-day stay in June, which is the last time they did one of these like this, where they reversed the decision in favor of the employee, is that now they've done a 60-day stay, which I guess is, they can do it in theory. That's the administrative law talking. But here, again, I don't know why any basis, why the point was, is if 30 days was fine enough all the times before, and now she's raising an argument that's full of beans, according to them, why are we going to 60 days? That would be the question that I would want to know. The commission, by delaying enforcement of its order for a short period of 60 days, see, that's as provided the respondent, should it decide to appeal, hey, go appeal. Hey, why don't you appeal this decision? Go ahead and appeal. A reasonable period of time to seek a stay from the court. The concurrence commissioner does not contend that there is support in the record for a stay. Instead, without hearing from the parties, the concurring commissioner speculates that the parties may suffer irreparable harm if a stay is not granted, and does not even address whether the respondent is likely to succeed on the merits of the appeal. It could prejudice the interest of one of the parties. Oh, I wonder who. For the commission to prejudge the issue and issue a stay with that. But that's what they're, without any note, they're effectively doing that, at least of an additional 30 days, or consideration of the factors which would guide a court in deciding whether issue to stay. Okay, so did everybody get that? One of the three judges is saying, or commissioners is saying, let's hold this off until a circuit court makes this decision, because, why wouldn't they appeal? Well, appeal! That's what that's saying. Okay. And then normally, apparently, 30 days is the rule. And the other two people who are saying, okay, we agree to discrimination happen, but we should, follow and get the employee, might prejudice the rights of the employee to not have them ever get paid. For example, you won, haha, but you never get paid. Now go on and get your minimum wage. The problem with that is then they've added another 30 days on there, and they admit that that's what they're doing. And so if it was arbitrary and capricious to do it until why would you do it at all? So that is, I think, what the internal coherent problem is on this one here. Well, you can see here, they altered the positions of the parties without really any statutory basis. They have the authority to do it. They just don't have any reason to do it, according to them. And again, they're extending it from 30 days to 60 days. In my opinion, it hurts the position of the parties a lot, and it makes it less likely to for the employer to. I mean, why wouldn't I go to the Supreme Court if I didn't have to pay the damages? It's baffling to me. Pursuant to WISTAT 22754, the institution of a proceeding for judicial review shall not stay. Oh, this is more comment. The enforcement of the commission's decision unless a stay is ordered by the reviewing court. The commission will not pursue enforcement while a motion for such stay is pending. The compliance report shall be prepared using the compliant reports form, and I can show you something of that. Fill this out. Show us what you did. Gross back pay, statutory set-offs, interest due, total due this quarter, total payment due. Wow. I would be really resentful if I was a business and got something like this. I really would. The respondent shall submit a copy of the compliance report to the complainant at the same time it is submitted to the commission. Within 10 days from the date of the compliance report that is submitted to the complainant shall file with the commission and serve on the respondent a response to the compliance report. Notwithstanding any other actions a respondent may take in compliance with this order, a failure to timely submit a compliant report is a separate and distinct violation of this order. This statute provides that every day during which an employer fails to observe and comply with any order of the commission shall constitute a separate and distinct order and shall pay forfeit not less than $10, no more than $100 for each offense. I mean, why would they ever pay? Procedural posture. This case is before the commission to consider the complainant's allegation that the respondent discriminated against him based on his disability and his use or non-use of lawful products off the respondent's premises during non-working hours in violation of the Wisconsin Fair Employment Act. Hereinafter, the Act. An administrative law judge for the Equal Rights Division of the Department of Workforce Development held a hearing and issued a decision finding that no discrimination occurred. The complainant filing a timely petition for the commission review of the portion of the decision finding no discrimination based upon his use or non-use of lawful product. So we took the discrimination to the EEOC, disability discrimination. The commission not review the issue of discrimination based on disability. While the filing a petition for review by any party vested communication with it to review the entire decision, the commission will generally not be inclined to exercise that jurisdiction to issues that are nearly expressed and implicitly raised by a petition for review. Here, the commission has exercised its discretion to review only the claim related to off-duty use of lawful products. The commission notes that although parties briefed the issue of whether the administrative law judge properly excluded medical record evidence, that issue is only relevant to the disability claim, so we don't have to deal with it. The complainant began working with the respondent in 1999. The respondent operates at multiple grocery stores in Wisconsin. At the time of this discharge, the complainant worked as a third shift stocker. Prior to February 16th of 2020, the complainant consumed alcohol on a regular basis during non-working hours and at locations other than at the respondent's premises. The complainant took an approved Family and Medical Leave Act leave from the 29th of January 2020 to February 26th, 2020 due to a back injury. While on leave for his back injury, the complainant received inpatient alcohol detox treatment at Rogers Behavioral Health. Yada, yada. This treatment was completed prior to the complainant being released to return to work from his back injury and while he was still on FMLA leave due to that injury. I did a pretty good job here so far. The respondent became aware that the complainant had received inpatient treatment during the FMLA leave and asked what he was treated for. The complainant responded honestly that his treatment was related to his use of alcohol. The respondent complainant requested the complainant complete documentation requesting a second FMLA leave to cover the time period that he was treated at Rogers Behavioral Health. And he did so. Oh, yeah, I forgot about that too. It's a good fact. So far, not bad, guys. I mean, they get facts to pick out and choose and decide the story, but so far, they don't seem to have missed anything. During the complainant's employment, the respondent had a policy requiring that any employee who attended rehabilitation to sign a last chance agreement, regardless of whether the rehabilitation took place or whether the employee's alcohol or drug use had affected his or her work. Zero tolerance policy, guys. On March 10th of 2020, the respondent Kenosha store manager Louis Ludeman presented the complainant with his last chance agreement that stated in part, whereas the employer has acknowledged that the company and to the company that he is seeking treatment for alcohol abuse and alcoholism, an employee's use and of possession of working or being under the influence of alcohol while working would be considered a serious violation of the company's policies that can result in termination. Whereas the company wishes to provide the employee an opportunity to remain employed by the company and reiterate its policies regarding alcohol use and possession while working and being under the influence while working. Accordingly, and in order for the employee to remain employed at the company employee, so this is you have no choice, employee and the company have agreed to set forth herein the minimum conditions to which employee must adhere. The last chance agreement also required as conditions of remaining employed that the complainant enroll in a medically recognized and supervised drug and or alcohol rehabilitation program and other counseling program. That he communicate the status of his treatment as well as the details about his treatment, jeez Louise, to the respondent. That's Woodman's, that he complete treatment and actively participate in aftercare treatment, and that he had submit to random alcohol and drug testing from Woodman's. The complainant signed the last chance agreement when Mr. Ludeman presented it to him, but later that day requesting a meeting with the regional manager, Mr. Malafa, to discuss the agreement. Good move on his part. You know what else was even better? He recorded it. This whatever you may say of anything about this particular case, this man recorded the right stuff at the right time. Boy, howdy. Because no, who are you going to believe? Some peasant or a lawyer? We'll see. The complainant signed the last chance agreement. Okay, Mr. Malafa met the complainant a few days later. Mr. Malafa informed the complainant that he had conferred with the respondent's general counsel, Sarah Eagle Chomi, regarding the respondent's last chance agreement policy. He informed the complainant of the respondent's policy and clarified that the complainant was required to sign the last chance agreement because the respondent had become aware that he had attended a rehabilitation program. The complainant was absent from work for a week from May 17th through May 22nd of 2020 based on his doctor's recommendation because he was being treated for vertigo. I don't know much about that one, but I know it's distinctly unpleasant. The complainant asked his doctor to submit FMLA documentation to the respondent regarding these absences, but the doctor failed to do so. What a jerk. But he's he's a doctor, so we can't he's not a peasant or anything. Following his treatment at Rogers Behavioral Health, the complainant remained sober for approximately 6 weeks. However, at some point he began drinking alcohol again. Complainant checked into a rehabilitation facility on June the 7th. He requested FMLA from the respondent in order to undergo rehabilitation treatment from June 7th to July 23rd, and the leave was granted. Following his treatment, the facility provided return to work release, and he returned to work for the respondent. While the complainant was in the rehabilitation, he spoke to Miss Eagle Chomi and confirmed that he was receiving rehabilitation treatment because he had abused alcohol. I think they said that didn't happen. So that's all right. On August 3rd of 2020, the respondent terminated the complainant's employment because of his use of alcohol. I mean, come on. This Sarah Eagle Chomi walked into the office and said, your employment, because you used alcohol, your employment is not an end. And my client recorded her doing that. So, I mean, that's a little anticlimactic there, people. But hey, the complainant did not consume or possess alcohol at work at any time during his employment with the respondent. The complainant did not report to work under the influence at any time during his employment with the respondent. The complainant's use of alcohol did not impair his abilities. Bam. Conclusions of law. The respondent discriminated against the complainant in terms and conditions of his employment within the meaning of an act by requiring him to sign a last chance agreement on the basis of his use of a lawful product off the respondent's premises during. They let this attorney off the old hook. I'll tell you what. I'll tell you what. Because again, Sarah Eagle Chomi, their attorney slash witness who got deposed, was the one who made the termination. Just being a little kind here, a little kind. I don't think they'd be that kind to all workers. But again, hey, everybody who wrote this decision is a lawyer. Memorandum opinion. Wisconsin 11132 provides that it is an act of employment discrimination to terminate from employment or discriminate against any individual in terms or condition or privileges of employment because of any basis enumerated in the statute. Includes the use or non-use of lawful products off the employer's premises during non-working hours. As one such prohibited basis of discrimination, this provision was intended to provide protections for the use or non-use of lawful products such as tobacco or alcohol. See these cases here from 2010. The complainant established that he used a lawful product, alcohol, off the respondent's premises and during non-working hours, and that the respondent took adverse employment actions against him when it required him to sign a last chance agreement and subsequently discharged him. The commission concludes that these actions were taken by the respondent because of the complainant's off-duty use of alcohol and were in violation of the old act. The respondent argues that it did not have a policy of requiring that any employee who had sought rehabilitation treatment to sign a last chance agreement. Rather, it asserts that it only required employees to do so if their drug or alcohol abuse affected their work. However, the evidence demonstrates that the complainant specifically inquired as to why he was required to sign the last chance agreement and recorded the regional manager's response. That here we go, baby. Props to the complainant there. Props, man. All right. Better give me my propers when I get home, is what I understand. That audio recording is in the record in this matter, and the commission finds it persuasive. The regional manager not only stated that the respondent's policy was to require any employee who had attended rehabilitation treatment to sign a last chance agreement, but he indicated that he confirmed that this information with Sarah, who the commission infers to be Sarah Eagle Chomi, the respondent's general counsel. Bam. Who testified that she made the decisions to require the complainant to sign the last chance agreement and drafted the agreement. At the time, the respondent required the complainant to sign the agreement. It had no evidence that the complainant use of alcohol had in any way impaired his ability to perform his work. Based on the foregoing, the commission concludes that it was the respondent's policy to require that any employee seeking treatment for alcoholism must sign a last chance agreement. Because the respondent learned that he had been treated for alcohol abuse. Since the complainant's use of alcohol, a lawful product, occurred off the respondent's premises during non-working hours with no evidence to suggest that he was impaired while at work, the commission concludes the respondent's decision to place him on a last chance agreement as an agreement was in violation of the act. So just putting him on the last chance agreement, not even terminating him, in violation of the act. I'll take that. I'll buy that for $1, but I also think I don't know that I hadn't thought of that in and of itself anytime recently. So good for them. I guess there's still more for everybody to learn, possibly including me. Next, the respondent argues that it discharged the complainant because of his attendance and not for any reason protected by the act. It argues that the complainant has offered no evidence that this asserted non-discriminatory reason for the complainant's discharge is pretextual. However, the complainant recorded the discharge meeting. Man, where would this fellow be? It would be a peasant versus an attorney. And we know how that goes. And that second audio recording, which is also part of the hearing record, establishes otherwise. The recording provides clear evidence that the respondent's reason for the discharging the complainant was his use of alcohol, not his attendant. That's, yep. Yes, sirree, Bob. During the discharge meeting, Miss Eagle Chomi confirmed with the complainant that he had abused alcohol, asserted that his abuse of alcohol was inconsistent with the terms of the last chance agreement. Wow. Let's just notice a little footnote here. As the administrative law judge Schacht noted in his decision, the complainant's abuse of alcohol did not violate the terms of the last chance agreement, which is limited to the use or possession of alcohol working or being under the influence of alcohol while at work. Oh, well, it kind of undermines the whole position, doesn't it? And informed the complainant he was being discharged because of that violation of the last chance agreement. The complainant's attendance was not discussed during the discharge meeting. Now, the problem here with all that, as I've asserted several times so far, is that Sarah Eagle Chomi is an attorney, and Eric Eisenman, the attorney who, on behalf of Woodman's, is also an attorney, and the recording speaks for itself. So, I mean, what they're saying here is that it's hogwash, and we know that it's hogwash because there's a recording. And it's a real problem in my mind that the attorneys, and it has been for years, that the attorneys here continue to say that they terminated him for um, attendance when there's a recording of one of those attorneys otherwise, as was written here by 3 other people. The commission has considered whether any of the exemptions to Wisconsin exceptions Wisconsin stat found in yada yada are applicable in this case, but conclude they are not. The respondent argues that the complainant's use of alcohol impaired his ability to undertake adequately his job-related responsibilities, a circumstance which would allow it to lawfully terminate the complainant's employment. However, as stated above, the respondent presented no evidence that the complainant's use of alcohol impaired his ability to undergo his job-related responsibilities. Evidence matters. The complainant testified that he experienced symptoms of withdrawal during some of his work shifts, but emphasized that it did not impact his work performance. The respondent's general counsel testified that the respondent had no evidence that the complainant was under the influence of alcohol at work or that he had used alcohol during any of his shifts. Further, there is no evidence that the complainant's use of alcohol or his treatment at Rogers Behavioral Health affected his attendance. The complainant missed no work because of his alcohol use or abuse prior to June 7th, when he began an approved FMLA leave. The respondent points to the testimony from Miss Eagle Chomi that the complainant's return to work from the leave of absence he took because of his back injury was delayed due to his treatment at Rogers Behavioral Health. However, the complainant credibly testified that he completed his treatment at Rogers Behavioral Health prior to being released and returned to work for his back injury, and that the commission sees no basis to conclude either that the complainant's alcohol use or his treatment for alcoholism resulted in extending the period of FMLA leave that was approved. While the complainant may have missed some work during June for reasons related to his alcohol use, he was already on a approved leave of absence at that time, so it cannot be reasonably found. It was, although it was found, but it could not reasonably be found. Thank you, Judge Schacht. The alcohol use affected his attendance or otherwise impaired his ability to undertake his job-related responsibilities. All props on this one to my paralegal, Mike Youngbluth here, a former union steward for the Milwaukee or the United States Postal Service, Milwaukee branch, um, and who spotted those FMLA attendance issues a mile away, and I never would have spotted them, no doubt about it. Finally, upon his release from rehabilitation treatment, the complainant returned to work, and the respondent presented no evidence to suggest that he missed any additional work as a result. So it sounds like they're trying to get him in here. They're looking for reasons to undermine his decision, but they just weren't able to do it. Um, for all the reasons set forth, the commission concludes that the respondent discriminated against the complainant in terms and conditions of his employment by discharging the complainant in violation of the act. The administrative law judge's decision is therefore reversed. Now there are 1, 2, 3, 4, geez, Louise, 6 pages about fees. We'll save that for some other time. I mean, geez, I think it went from like $70,000 to $42,000 because of the what was discrimination, disability, what was discrimination, non-use of lawful products, like that. I agree with this decision in all respects, except for the provisions requiring compliance. This is Michael R. Gillick, chairperson, with 60 days of the order. I would continue the commission's long-held practice of requiring compliance after all appeals have been exhausted. To my knowledge, no party has ever asked for an earlier date for compliance, and there are many reasons. Well, give us a chance. How about? I mean, nobody. Here's what I object to this is that the parties were never asked to brief their positions on this. So this is entirely an intra-judge issue that they're using us as a vehicle to discuss. To my knowledge, okay, it is likely that the complainant would struggle mightily to reimburse any money paid. What first, if the decision were reversed on appeal, it is likely that a complainant would struggle mightily to reimburse any money paid. Okay. Second, under the present practice, a complainant's monetary award earns 12% interest, an amount not otherwise available to a complainant. That's the best interest you're ever going to get? Reversing a reinstatement required by the order would likely create serious problems for both parties, particularly if it had been required displaced. The guy's already fired. No, this is all for it would require. How about we find people guilty or have to have liable for discrimination, but never actually enforce the judgments? How about that? Because that's what this is ordering. The majority instead has decided to require compliance within 60 days of the issuance of it to indicate that if the respondent chooses to appeal, it may seek a stay from the circuit court judge. Well, it doesn't need to indicate that. That's the law. Why are you getting involved in this? The majority discusses that the criteria of a circuit court would consider when deciding whether to grant a stay and suggests that a commission order that does not require compliance after all the appeals have run is improper because the commission has not considered these same criteria. However, the commission is not a court. Good point. One, it determines the time at which its order will be effective. It is not granting a stay. Yeah, I completely disagree with that. Completely disagree with that. The commission is obligated to set a time in which this order becomes effective. This says the statute which provides the special orders such as the commission order take effect as directed in the order and acts within its authority when it chooses to make an order effective after all appeals are run. We have the power to do this. While I acknowledge that the commission also has the authority to require compliance at an earlier point as the majority orders here, I do not believe that is compelled to do so, or that to do so is in the interest of the party or better effectuates the purpose of the act. It is rather my considered opinion that all parties are better served by requiring compliance only after all appeals are exhausted. Wow. That he's basically saying that there's this WISTAT 103.005.6b, which provides that special orders must say when they are to take effect. So he's turning that into the power to indefinitely annul the Wisconsin Fair Employment Act until the appeals are exhausted. Which Circuit court, appeals court. I mean, it's like 5 years, 6 years minimum. And this guy's already been waiting 3 years. Does Do you think that the citizens of the state of Wisconsin gave Michael Gillick, the chairperson of the Labor and Industrial Review Commission, the power to essentially nullify the Wisconsin Fair Employment Act for 5 years? And who does that benefit? Does that benefit the employer more or the employee more? What do you think? Because it seems pretty obvious. And why are they using this case as a vehicle for this? And why are we not allowed the due process? Because whether it's 30 days or 60 days affects my client's rights. And my client should have the right to have participated in this decision before they made it without reference to him. So that's where I am with that. Thanks for sticking with us. We'll keep you informed.